Good evening, everyone. Well, tonight we have our guests. I got my schedule correct. And tonight we have as our guest, we'll start from the far side.
Can you switch your line
Switch to the other side? Sure. We have Levine, who is a First Amendment lawyer, and we're going to talk to him about that subject and about court action today. And we're going to talk to Sharon Fawcett, who's the director of the Presidential Library System, about how that operates. And Archivist Alan Weinstein is a historian as well as the archivist, and we're going to talk to him about the kinds of information that exists in the archives, both from an historian's point of view and from the archivist's point of view. And all of us are interested in the whole issue of information. What is the quality of information that we need in a democratic society, and what we're actually getting? Lee, let's start with you. When you look at that question and you think of as the First Amendment as being an important tool for us, what kind of information do you think we need as a society in order to have an effective government?
Well, the premise of the First Amendment is that it is essential to the operation of a democratic government where the people are essentially the governors and their elected representatives are there to do their bidding. And the theory is that for people to be able to intelligently decide who to vote for, intelligently decide what policy preferences to express to their elected representatives, they need information. And the idea is that the flow of information should be as free as possible, consistent with the ability of the democratic society to maintain itself. So the operating premise, and it motivates most decisions by the Supreme Court interpreting the First Amendment, is that you start from a presumption that the flow of information needs to be free. Legal restrictions on the dissemination of information or the availability of information has to be as limited as reasonably possible, and the burden is on the government to justify any kinds of restrictions that they might impose. Now, when you get into the details, that all sounds very nice from the macro level. When you get into the details, there are all sorts of distinctions, and I guess the best way to put it is that there's kind of a hierarchy of government actions in terms of how distasteful they are from a First Amendment perspective. On the one end of the spectrum, you have what are called prior restraints, and that's the government going out and telling somebody in advance, you can't publish this, you can't disseminate this information to the public. And we have a very, very high presumption under the First Amendment that you cannot have a legal prior restraint except in the most extreme circumstances where the very national security is really imminently at stake. Then you move down the continuum, and at the far other end is whether the First Amendment provides citizens with any affirmative right of access to information that the government holds. Mm-hmm. And the courts, through the first 200-plus years of our constitutional history, have said that right's a lot more limited, and that there are very few circumstances in which the First Amendment affirmatively entitles somebody to say, hey, I'm entitled to that information, I'm entitled to that document, I'm entitled to that material. So far, the First Amendment right of access has been limited largely to the right of the people to attend criminal judicial proceedings and get access to criminal judicial records, and hasn't really extended to the executive branch. That's much more, or the legislative branch, that's much more been a creature of statute and regulation. And then in the middle, you've got this whole area of when can the government impose punishment on somebody for disseminating information, not restraining it in advance, but putting them in jail or socking them with an award of damages, like in a libel suit. Mm-hmm. And there, the First Amendment has a lot to say about the circumstances under which a government can legitimately do that, and the circumstances are few. They're more than in the case of being able to impose a prior restraint, but comparatively relatively few.
When the First Amendment was written, what were the ideas behind those writing it. Did they decide that that we really should have this very open system and that they held to it? Or was there a difference between what they said and then what happened once the government went into effect?
That's a very good question, and it ought not to surprise us to know that then, like now, our elected leaders did not speak with one voice. They had disagreements among each other. If there was any point of agreement, I think it was on the basic notion that dates back to Blackstone and the common law in England, that freedom of the press means, freedom of speech means no prior restraints except in extraordinary circumstances. I think there was a general consensus on that. How much further it extended beyond that, historians, law professors fight about that all the time. In one of the most famous Supreme Court cases in dealing with First Amendment rights, the case of New York Times versus Sullivan, Justice Brennan wrote that the lesson of history is that those who framed the Constitution believed that the Alien and Sedition Acts, which basically criminalized criticism of government, that were passed shortly after the Constitution was enacted, that the judgment of history is that the framers really believed that that was unconstitutional, that kind of punishment of people for criticizing the government violated the First Amendment. But the very fact that they were passed suggests that there wasn't really a consensus on that point at the time.
Can I put a footnote in, Martha?
Sure.
If you come to the National Archives, you'll see the original draft of the Bill of Rights. And it comes always as a disappointment to believers and lovers of the First Amendment like ourselves here, that the First Amendment wasn't the First Amendment at that stage. It was number 3. Amendment number 1 had to do with the number of individuals you needed in order to have a congressional seat. And if we had followed the framers' prescription on that, we'd have a Congress that met in the MCI Center. But we didn't. Number 2 had to do with another matter, which is now in the Constitution. And finally, you get to the First Amendment, which became the First Amendment by the fact that the other two didn't go for it. So it wasn't as if you had a bunch of founders who were just obsessed with this one issue over there. I don't know. One among many issues.
Well, in thinking about the archives and the kinds of information that you have there, what is the guiding policy that you have as far as information? Is what information the public needs?
Well, the public needs as much information as we can possibly give it in every conceivable way. We have, first of all, some misunderstandings. People think of the National Archives as one building in Washington, downtown, where the Constitution and the Bill of Rights and Declaration of Independence are kept. That's a great building. I have my office there. We have about 1 billion documents. I counted each one, and I think they're all still there. We have about 9 billion documents in the system, as Sharon could explain better than I could, but that includes now 11 presidential libraries, soon to become 12 and 13 with Nixon and Bush 43. Mm-hmm. We have 14 regional archives. We have 17 regional record centers, and they're scattered all over the country, from Alaska through New England. And so the public, basically, the National Archives is a national institution and is open every day for research, for scholars. Actually, genealogists are probably our largest number of users. But in fact, I found the records of my own family there, because my parents were immigrants from Tsarist Russia. Never had that information until I became an archivist. So you need every conceivable kind of information that you can possibly get. It's very hard to delineate it and reduce it by category.
Mm-hmm. How is it decided what kind of information is kept? Because you can't keep everything.
We have a very, well, I want Sharon to jump in this one, but we have a very careful process of evaluation. I sign off on every reduction of information. Every time that something is not kept, I have to sign off on that. Mm-hmm. And what we end up is, 2 or 3% of the material we actually keep.
Well, what happens in it's very interesting in the presidential world. For presidential records, we keep most everything. I would say 97% of records created in the presidency are retained. The exception is some bulk mail, that is the public writing to the president. We used to keep it all, but the bulk mail now exceeds the quantity of important governmental correspondence, so there isn't room in the libraries to retain all of the bulk mail, so we sample that. For federal records, it's the reverse. 97% gets disposed of, and about 3% is retained as important. So you keep records of the higher level officials in the cabinets and agencies, and you You retain records that show the actions of government, the transactions, the important documents that you need to retain that document how decisions were made, what the rights of citizens are, et cetera. So those are the kind of documents that you
And
want
it's
to
also
retain.
fair to say, I think, would you agree, Sharon, that basically we are far behind in the processing of records because of budgetary factors. We just don't have the money to hire the archivist to basically keep us up to date on the material in the presidential libraries and the material in federal records.
How do you know that people actually keep the records? Like, say, in a White House, say somebody decides that, gee, they really want to get rid of a few things because an issue has become controversial or some action that they take is bubbling to the surface. How do you know that the information is actually retained?
Well, we can't know for sure because we don't police the White House staff. The White House counsel's office issues at the beginning of the administration and to new staffers coming into the White House information about their record-keeping responsibilities. I frankly think it would be very difficult to destroy all copies of a record. This is a society where we're not the paperless society anymore. We make many, many copies. The electronic versions are definitely retained. It would be very difficult to delete all of the electronic copies because of the records management system that they have imposed for electronic records. Does someone toss a draft into the wastebasket? I suspect a few drafts get thrown away, but I think most are retained and saved, and they go to the files.
It's also, if you're in the White House, you have to be cognizant of the Presidential Records Act. You have to be cognizant of the fact that down the street at the National Archives are people waiting to receive your records on an almost weekly basis. The folks at the White House were depositing material with us continuously, particularly the presidential.
One of the I don't know, elements of presidential record keeping that has come up dealing with staff and a lot of interviews that I've done over the years is the tendency of people not to create the record in the first place. Say during the Clinton administration, when staff had meetings, and often nobody would take a note, so that they wouldn't have a record of the meeting because they were so worried about their records being subpoenaed, which was a real concern because they were subpoenaed all the time. So they just decided the easiest way of dealing with it was not creating the record. So how do you guarantee that a record is created?
Well, you can't. And the fact of the matter is, you're absolutely correct. I think that the recent presidents, not just Clinton, not just our current president, but recent presidents, have been very careful about what they write, what they keep, what they save, for a variety of reasons. But there they are. That's the world we live in.
Yeah.
Ironically, the most well-documented presidency, I think, is the Nixon presidency.
Yeah.
And is
Lot of
reflected
good-
in the
lot of good
number not just the tapes alone of the conversations,
Right.
which are an incredibly rich source, though difficult to use and understand. There are many scholars that are working on making those tapes more accessible to students and others who want to use them more casually. But Nixon kept detailed notes. His staff kept notes of all their meetings. One of the ways that our staff who review the tapes are able to understand the tapes and understand the context of the tapes is they go to the meeting notes of Haldeman and Ehrlichman and others who worked for Nixon because they had detailed notes of what took place in the meeting, who was at the meeting, and so it helps them to understand the conversations. Plus, Nixon himself wrote extensively on documents. There's much of Nixon's handwriting there and explaining his thoughts about a matter. It's an incredibly documented presidency.
You wrote at that point with the expectation that no one would ever see this again. That was the firm expectation of those in government until an act that I've used and we've all used around the Freedom of Information Act was passed. I think it's fair to say that my lawsuit for the Alger Hiss files in the 1970s was the first victory for release of government material of historical interest. And at the time, the FBI had 3 people in its Freedom of Information Office, 3 people, because there just weren't many cases that were being won. But to this day, using the same example that Sharon is using, you couldn't write a good biography of J. Edgar Hoover without using the marginal notes that Hoover wrote on just about every document that came past his desk. He was an inveterate scribbler, and he had every expectation that no one would ever look at his scribbles except people who worked for him. Not true any longer.
Let's talk about the Freedom of Information Act and its importance. Do you work on the Freedom of Information Act? Are you involved in it? Can you talk about how it came about and the difference it makes as far as the presumption is concerned of what happens to a document?
Okay, well, it came about in its current form largely as one of the post-Watergate or Watergate era reforms, and I guess what's important to know about it is that it applies only to administrative agencies in the executive branch. It doesn't apply to the legislature. It doesn't apply to the courts. It only applies to administrative agencies in the executive branch. And what it does is it creates a presumption that all documents created by a federal administrative agency or department of the executive branch are open and available to the public. It has exceptions, and the litigation is largely over the exceptions and whether or not a particular document or request falls within one of the exceptions. But it starts from a broad overarching premise that there is a presumption of public access to documents and records created by the executive branch of the federal government through a department or agency. And all things considered, the exceptions are relatively narrow. I mean, there's a lot of people like me make a living litigating over whether an exception applies or not. I'll say two things about the Act from my perspective, which is largely representing the news media in various content-related matters. It is a very, very useful tool to the extent that journalism starts to kind of trend toward history, where you're looking at longer with a longer perspective on a piece or a more broad focus on an issue. To the extent that you're looking for a hot document that is going to provide breaking news on some important issue, it's virtually worthless because the delays that are built into the Act and the ability of the government to use the Act to delay for months and months and years the turning over of responsive documents, it really isn't a very useful tool for daily reporting, but it is an enormously useful tool for broader form reporting and looking at trends and issues over a period of or not with respect to a specific breaking news event.
But it comes at a price in public access. First of all, I couldn't agree with Mr. Levine more that there are very few smoking guns in FOIA requests. But the time, and Sharon can give you more of the details than I can, the time it takes to process a FOIA request, if it was spent in bulk declassification, you would get a much greater number of documents released because we pay inordinately sensitive attention, and we should. We're legally bound to do that, but beyond that, we're responsible for the records. To every FOIA request that comes in. And they're responded to. I think we have a pretty good record in terms of the number of days before we respond and so forth. Every agency has that issue.
Yeah, I know I got in a FOIA request from the George H.W. Bush Library. I think it took 4 years.
Did it really?
Yeah.
Well, the Clinton Library...
And the items that I got were things that really never should have been.
Get us some more money. Sharon will process it.
and the problem was in getting to the processing of them. The Clinton papers were open to FOIA on January 20th of this year. 5 years after the president leaves office, presidential records are available to FOIA. Well, within a week of their opening to FOIA, they have a 3 million page backlog because that's how much people have already requested. There are 8 archivists there, and it will take them a considerable amount of time to do that, to do those 3 million pages, but every day new FOIAs are coming in, and the backlog is building. And the way you search for a FOIA request, you get a request for a certain subject, and it rarely is it as easy as a single item. Those we love because we can take care of those very quickly, and we run a short queue to handle the simple single or 2 or 3 document requests. but most are for broad subjects. And those subjects are scattered in files throughout the library, and that means the staff has to search through the entire holdings of the library. In the case of the Clinton Library, there are about 75 million pages of paper and another 75 million pages of email. So that's a lot of material to search through and pull the items and then begin the review.
The Clinton presidency produced emails at the rate of about 300,000 a month, as I understand it. The current Bush presidency is producing them at the rate of about 1 million plus.
$1 million a month.
A month.
Well, they're going to be just a terrific source of information as far as the scholarly community is concerned, and also journalism. Can you give some cases that where FOIA was important to journalists?
Oh, that's a good question.
Some stories that came out of some FOIA requests.
I think you stumped me on that one. I mean, there have been many, and they tend to be these kind of broad enterprise reporting kinds of things, looking at issues like mine safety or the environmental hazards or what have you.
That's the area that I would have said. Federal regulation, environmental safety of one sort or another. Those cases make headlines only for a very short period of time, but they have changed policy in many instances. If you can show that something was the case and the government agency at the time was saying something else, you've got a wonderful setup for a congressional debate. And Congress, in its infinite wisdom, of course, exempted itself from the Freedom of Information Act, as did the courts.
And on what basis did they exempt themselves? Did they discuss it, or why they were going to exempt
Martha,
themselves?
it's none of your business.
They do that all the time.
Yeah, from a lot of regulations, safety and and affirmative action, all sorts of things. Alan, from a scholar's point of view, can you think of some books that have come out of FOIA requests?
Well, I've written one of them.
Yeah.
Called Perjury, the His Chambers case, where basically without the material that emerged from the FOIA process, I couldn't have finished the book. It would have been impossible. And scholars, I think, beginning in the mid-1970s, have used FOIA. Historians have used it very freely. Trying to think of whether there would be any major books. Lee, I'm blanked on that. Sharon.
Yeah, there have been I know there have been a number.
Your clients, you must have had some clients who were historians.
Well, and I'm sure I have, and I'm just blanking on it. I'm sorry.
I was thinking of one case in the first Bush administration on John Sununu. I think the Washington Post used a FOIA request for the military travel of the chief of staff, and then it came out that there were instances where he was using military aircraft for personal purposes.
But they would have FOIA'd the military for that. The White House itself isn't subject to
Right.
FOIA
Right.
during the administration
Yeah.
and not for 5 years after the
it's
administration.
And it's a tool. The whole book isn't produced by FOIA, for the most part. I'll give you my own example. At the archives, there was an archivist who was there in 1962 when I first used the archives, named John Taylor. He's still there. You know John.
Yeah.
He's just turned 85 years old.
Yeah.
And he's still working away. He's amazing. But up here is John's response to the archive. He has it all. His memory is absolutely sharp. And basically, a scholar, most recently someone working on Iris Chang's books wanted to talk to somebody about this, and I called Mr. Taylor, and he said, I advised Mr. Chang on all her books. So he said, just bring her along. He's a walking archive. And we have not just one, we have a number of people like that over there. So FOIA requests, very important, but the archivist is critical here.
Mm-hmm. What are the kinds, if we all agree that that citizens benefit from having information available, what are the pressures that cut back the amount of information that we get? Because say, as far as the presidency is concerned, presidents come in saying that there's going to be an open administration and that they're going to provide as much information as they possibly can. Richard Nixon said that, as a matter of fact. Ours would be an open administration.
Sure.
I think the area since the Presidential Records Act passed, that causes the most limit to information is the restriction on confidential advice given to the president. Now, it's very interesting that prior to the passage of the Presidential Records Act, and Ronald Reagan is the first presidency impacted by that act, presidents had been donating their records to the federal government, to the National Archives, and basically with few restrictions. Restrictions for national security information, restrictions for things that might embarrass or invade the personal privacy of a living individual. They didn't suggest that confidential advice was an area that they thought should be restricted. And archivists in those libraries reviewed material and opened material all the time pertaining to confidential advice. Only when it crossed into the area of embarrassing somebody who was still living did it get closed.
Restrictions on access, I think, number one, start with the fact that our American media are strong, vigorous, and incredibly competitive. Try to imagine, for example, the Roosevelt administration. How long would the fact that the president was crippled remain in today's media? I mean, virtually impossible. Just somebody would have published it. It would have gone out there, the blogs or whomever. And with every day it becomes, I think, more competitive, and that's fine. That's good. There's a broader range of media in this country for one and all concern. In fact, it has led to the fact that a growing number of Americans could define themselves as journalists and do define themselves as journalists, whether on the people who run the blogs and so forth. Okay, so in that kind of a world, the competitiveness is everyone's looking for some story that hasn't been told, or some angle that hasn't been used. Where best to look? You look in the government. You look in the archives.
Do you think also that we have changed our views of what information we think that we need? That people today feel they have a right to more information than they did at one time.
No question.
So, for example, we have the press secretary's daily briefing is now televised, and people accept that as the way that should be. Whereas in, say, in Roosevelt's administration, the briefings were pretty much a private relationship between reporters and the press secretary. And the press secretary could go off the record. He could go on background to explain things. And you don't have that. Today, people want to see the individuals.
Try to imagine the press cohort today gathering around a president's desk the way they did in the Roosevelt era.
Now, it's hard to say what's the cause and what's the effect, but I think a lot of it has to do with each successive administration has gotten more and more sophisticated about managing its message. And managing the message means controlling what information gets out and doesn't get out. And there's a component of that that involves keeping information secret for whatever reason, because it's inconsistent with the message, because they don't want to detract from the message, for a whole variety of reasons. And that, I think, to some extent has exacerbated the adversarial relationship between the press and the presidency, in the sense that the press is trying to get information that's not part of the daily message or undermines the daily message or explains it in more detail. And that I think has created this odd, almost essential inconsistency that we have more information than ever before, but there also seems to be more of an effort by successive administrations to control what information gets disclosed. And the biggest area in which this impacts, and it's in the headlines every day these days, is the ability of the government to classify information in the name of national security. And the use of, on the one hand, the use of the classification system to keep information secret, and on the other hand, the use of almost, I don't know what the correct term is, but frequent on-the-spot declassification of information by senior officials like the president and the vice president, because they determine that it's in their best interest to get classified information out to the previously classified information out to the public, and that creates all sorts of tensions.
Haven't we found that through the years that one thing an administration can count on is that people are always going to leak? That as much as they're going to try to keep things under wraps, and in this administration, they've been quite successful at the White House of being able to focus on what things they want to focus on and keep information that they want private to be private. However, within the administration on policy issues, there just leaks all over the place, and on very, very big issues, particularly on things that relate to national security. So there's always going to be a battle, and difficult for an administration to win.
But it was pretty much a battle going back to Jefferson's day. Remember, you're talking about the Alien and Sedition Acts, you're talking about jailing journalists, you're talking about, this of course happened in the First World War, it happened to a lesser extent among journalists in the Second World War. What we didn't have then was a cadre of lawyers like Lee and an old friend of mine, Joe Rao, the late Joe Rao, and others who fought back on behalf of civil liberties with the media and other things, even in the McCarthy period in the 1950s. I'm more fascinated by, or as fascinated by this phenomenon, by the transformation of the media in this country over the last generation, say, or generation or two. I mean, when you think about it, Watergate, the culmination of Watergate is now 32 years past. And yet, how many journalists do we all know, friends and people we work with, who wouldn't yearn to have a Watergate-style story of one sort or another? Now, the Watergate-style story has a number of dimensions, one of which is the fact of the exposure of things being done in the Nixon administration, including the president, for actions which Congress was prepared to impeach him and to convict him of, probably on impeachment had he not resigned. We have some residue of that left over, and I think the, what should I call it, the gotcha phenomena. And we can go into some detail on this, but I think we're all part of this process. The media, the government, the scholars, all of us. So it's very hard to blame any particular one element for whatever changes we're looking at.
Wouldn't you say that the people for a long time trusted government and thought that whatever their leaders were doing
Sure.
was undoubtedly according to law?
The world I grew up in.
And then gradually, as more and more information has come out about governmental actions, then people don't make that same assumption. And also the standards that we have for our officials
Sure.
are quite different. You look at the kinds of things, like say in their personal lives, that dalliances that the presidents had that reporters knew about but didn't discuss.
Sure.
But gradually people decided that that actually did have something to do with how they ran their public office. So today we want a lot more information, and a lot of it is information that people just simply, that White Houses and members of Congress as well, and others don't want to provide.
Well, we've all become Gorbachevians, trust and verifies. Spirit of the day.
Do you think that there is a golden age of information when you're looking at the relationship between the press and government and what kinds of information that we should have? Do you think that there was a time period we would want to go back to, or is it something, are we better off today than we have been in the past?
Oh, that's a good question. I bet the answer is different from a legal perspective than from a historical or a public policy perspective. I'll give the legal perspective. I think that, for me, the golden age was probably from around 1964 till about 1979, somewhere in that period. And that's largely because in the latter stages of the Warren Court, there were a number of incredibly significant decisions that expanded the First Amendment rights of the press and the public to unprecedented proportions, and that the lower courts were much more receptive than they are today to arguments about First Amendment rights or advocating for First Amendment rights. You know, you had New York Times versus Sullivan during that period. You had the Pentagon Papers during that period. You had Watergate and the passage of legislation that reflected a general public view that what the press does is a good and salutary thing that ought to be facilitated. And somewhere after that, the tide turned. And, you know, it's a real open question today whether if some of these landmark cases that we rely on came before the courts today, they'd be decided the same way. So I think most of the 60s through the early 70s were probably the heyday.
Sharon?
Well, I think it's a mixed, I have a mixed judgment about it. I think it's important now that there is a right to access. It's not a right to access to information that the framers of our Constitution envisioned. I don't think the First Amendment covered access to information. It really, we can credit the French and the French Revolution with the modern archives concept and the right of access to information. But the Freedom of Information Act is a boon and it's a bane. The problem is that neither Congress or the executive branch has provided the resources to adequately fund it and make it easy to provide the information to people. In some cases, yes, government officials may be trying to avoid the release of information. That's not true at the National Archives. At the National Archives, we very much want to get the information out, but we don't have the resources to get it out as quickly as we would like to.
Mm-hmm.
Can I give you two answers?
Sure.
Quickly.
One is an historian and one is the archivist.
That's
Yeah.
right. All right, I'll start with the archivist. Well, yeah. It seems to me that the Roosevelt presidency was a great time, ironically enough, for archivists. The President of the United States spent a lot of time, Roosevelt did, focused on the archives. He has this little plaque in front, and he wanted his burial plaque to be right in front of the archives building. His administration built the building, and he attended to it even in wartime. He sent these very eloquent letters about the importance of documents and using modern technology and so forth and so on. So that was pretty much a golden age for archivists, not in terms of the quantity of information, but in terms of the responsiveness on the Hill, in the White House and so forth. For the most part, we've been ignored, with some exceptions, except for that brief period when everybody wanted the archives independent. But that has more to do with Richard Nixon than anything else, because the Nixon-Sampson agreement, GSA administrator, led to the passage of legislation holding those papers and tapes. For a historian, when I was a student, I was cognizant of the line of Jacques Barson, the Columbia scholar, when he was asked on a show called Information, Please, when he would have preferred to live in history. He said, "Oh, that was easy." He said, "Rome, just after it became decadent." but for me, to start somewhere in the early 40s during the war, and to have gone through the beginnings of the Cold War, the internationalization of American policy, up to at least Brown versus Board, 54, but really up to the March on Washington, which I was at and which I have fond memories of. So that 15 to 20 year period is my sense of where for historians at least.
And you think information was that it flowed pretty freely. One of the things you could say is that Roosevelt had very frequent press conferences in which he explained policy. And that would be one aspect of that. But
women didn't get into the picture in a very visible way until the 60s and 70s. African Americans not until the 50s and 60s. So we have whole large chunks of the American people who were not really addressed by historians or by archivists, for that matter, for long periods of time. We're first getting around to doing that.
Let me add something here, too. In terms of presidential records and materials, the United States makes those records available sooner than any other country in the world. No other democracy, certainly no other totalitarian society makes the records of its highest level policy official available as quickly as we do. And it's interesting, it's a late tradition for the U.S. This began with Roosevelt, with his decision to donate his papers to the government so they would be accessible. What happened prior to Roosevelt is the president's papers were dispersed. Many were destroyed by wives, by sons, by associates, etc. They were sold off, they deteriorated in basements. Look what happened to George Washington's papers. They got shipped off to various places and were used by people to write histories, and they cut them up and all that sort of thing. So having them together now is a great resource, and getting them open as quickly as they have been open is wonderful. Abraham Lincoln's papers weren't opened until about, I think, 1948 or 50 before they were open, nearly, some 80 years after he was assassinated. But now president's papers are open beginning to be open within 3 or 4 years of their leaving office.
What's your favorite period?
Well, I think in looking at, I think in terms of, say, the presidential press relationship and what we know about a White House, I think we know more now than we used to. In Roosevelt's time period, you didn't have the memos. I mean, you had people talk to one another, and if they didn't write it down, as if it didn't exist. And even in that period, he could decide what information was released. So if he had a press conference where he didn't make mistakes, I mean, he knew what he was going to say, and he didn't have to walk back on things. But Truman, say Truman in a press conference talked about how McCarthy was the biggest friend that the Soviet Union had, and so he had to walk back on that statement, and his reporters right off said that they were that was going to be a hot quote, and so he went back on it. But president could do that. Today, presidents are on the record. And the president has not just his press conferences, his short question and answer sessions, his press secretaries on the record twice a day. And they can't tell people one thing in private and another thing in public. So as messy as the relationship is, I think we're better off today.
J schools have gotten tougher. For example, another famous Truman press conference, he was asked about the House Committee on Un-American Activities and his case. He said, true. And the reporter shouted out, "Mr. President, do you think this is a red herring?" His answer was one word, yes. Headlines and throughout the United States. President declares UI committee red herring.
Yeah.
You never said
that happens. I know that happens to press secretaries.
Now it's become a custom, but it's frowned upon, isn't it? You're frowned upon it.
Yeah. Do you think that the economic difficulties that news organizations have impacted what information they are able to get? Is that limiting, or is that only limiting in some places?
You can argue that both ways, I think. I mean, I do think there are news organizations in this country that I think are more well-funded and have more resources at their disposal than ever before in history and are extremely aggressive about gathering and reporting the news. There are others that have cut back substantially for economic reasons, especially local newspapers in local communities, especially group-owned local newspapers in local communities. But on the other hand, you have this whole area of new media on the internet and bloggers and this army of citizen journalists that never existed before in such a powerful and effective form. So I guess net we probably have more effective ability to ferret out and report the news than ever before, although not in the ways we've, at least over the last generation, traditionally come to think of what news reporting is.
If we looked at, say, the early part of the 19th century and what the public knew about its government and expected to know about the government, what things were available in that time period?
Well, you had a public that really didn't want to know very much about the national government, and not until the Civil War. This was not the source of government was state and local. That's the heart of government. Now, at that level, you had newspapers, of course, and the newspaper was a going commodity all through the United States, from basically the 18th century on, from the Zager case, other cases just going on.
But what kinds of things would they be able to report? What would they be reporting about the national government?
Well, it depends on which newspapers you read, then as now, and it depends on whether you're in the middle of a presidential campaign. Probably the dirtiest presidential campaign in American history, by at least the account of a number of historians, myself included, was the one between John Quincy Adams and Andrew Jackson. Because you had the Jackson people accusing John Quincy Adams of having been a procurer for the Tsar of Russia while he was ambassador there, and you had, of course, the Adams people talking about Jackson living in sin, quote unquote, with his wife Rachel, and they went at each other, hammer and tongue, back and forth, back and forth. It was not very edifying, any more than the newspapers of the Jeffersonian period were very edifying. In that sense, we've calmed down a little bit, I think it's fair to say, in the media. But, what sources of information?
If you looked at, say, the presidency and the Congress, what kinds of things would one be able to find out on a regular basis?
Pretty much everything you want to know. Remember, Congress didn't meet for very long every year. The president left Washington in the summertime. If we had had the telegraph in the United States in the 1830s at the time of the Nat Turner insurrection, we might have had civil war then. But the difference, one of the main differences between the coverage of the John Brown raid, for example, 1859, and Nat Turner in the early 1830s, is by the time of the John Brown raid, you had the telegraph, the news went north and south everywhere at once. The great difference is, then as now, was the speed in which information was conveyed. And that changed the whole drama.
What are some of the today? What are some of the kinds of actions that the courts are taking in relation to news organizations that are different than they were, well, let's say 25 or 30 years ago?
Well, the biggest issue, of course, which you're reading a lot about in the press these days, is the issue of whether there is a reporter's privilege. That is, the extent to which the law will protect the journalist in offering a promise of confidentiality to a source of information and then being able to keep that promise when they're subpoenaed to testify either before a grand jury or in a civil lawsuit or in a criminal trial. Believe it or not, the Supreme Court has only addressed that issue once. It addressed it in the early 70s in a case called Brandsburg versus Hayes, and talk about how judicial appointments can make a difference. When that case was petitioned for review in the Supreme Court, Justice Black and Justice Harlan were on the bench, and between the time it was petitioned and the time it was heard, they had both died and were replaced by two Nixon appointees, and the case went 5-4 against the press. And it's the one and only time that the Supreme Court has opined on the issue and said, in a very closely divided opinion, some refer to it as a 4-1-4 because Justice Powell wrote a concurring opinion that seemed to be sympathetic to the dissent, but yet he joined in the majority. But the court appeared to rule in that case that, at least in the context of grand juries, there is no reporter's privilege grounded in the First Amendment. For the 30 years or almost 30 years thereafter, it was as if that case never existed in lower courts all over the country. In every federal circuit, or virtually every federal circuit, virtually every state Supreme Court held that, in fact, Brandsburg notwithstanding, or maybe in some cases even an interpretation of Brandsburg, was that there was a First Amendment-based reporter's privilege. And for most of the last 30 years, it hasn't really been an issue until recently. And in the last 3 or 4 years, there have been a number of important judicial decisions, not at the Supreme Court level, but just below, holding either that there is no privilege at all or that it operates weakly and doesn't protect journalists in a particular case, as a result of which we have an unprecedented number of journalists currently in contempt or threatened with contempt, and some have gone to jail and others have been fined, and that issue, is very much with us, and Supreme Court, of course, decided not to hear the Judy Miller, Matt Cooper appeal. They'll have another chance very soon in a case I'm involved in, involving a lawsuit brought by Wen-Ho Lee, the nuclear scientist from Los Alamos, in which 5 reporters have currently been held in contempt. And maybe they'll hear it, and maybe they won't. But that is the big battlefield right now from the press's perspective.
Can you tell us about that case?
The Wen-Ho Lee case?
Yes.
Sure. Wen-Ho Lee, as many people know, was a nuclear scientist at Los Alamos. He was suspected during the Clinton administration of being involved in the transfer of classified information to China. He was investigated. He was never indicted for anything having to do with the disclosure of classified information to China, but he was indicted on multiple counts involving the downloading of classified information into non-secure locations and that sort of thing. A very controversial indictment, a lot of allegations that he was being singled out as some sort of scapegoat by the Clinton administration. He ultimately pled guilty to one felony count, and all the other charges were dropped, and he was released in exchange for time served. He'd spent an enormous amount of time in solitary confinement. During all of this, he brought a civil lawsuit against the government under the Privacy Act, which is kind of the twin sister of the Freedom of Information Act, arguing that the government had released information about him that was protected by the Privacy Act, and therefore he had a right to recover damages from the FBI, from the Department of Energy, from the Department of Justice for these leaks of information, personal information about him that was protected by the Privacy Act.
What kind of information?
His employment history, information about his wife's employment history and their travels, information about the scope, about the ongoing investigation against him. You know, he failed the lie detector test. Did he fail the lie detector test? Didn't he? That sort of thing. All of which he argues in his Privacy Act suit against the government is protected by the Privacy Act. Well, you only violate the Privacy Act, much like the Freedom of Information Act, if the information about you was disclosed by one of the agencies that's covered by the Privacy Act. So if the leaks came from the White House, he doesn't have a case. If the leaks came from a congressional committee, he doesn't have a case. If the leaks came from Energy or Justice or the FBI, he does have a case. So he argues that I need to know the sources of these leaks that appeared in the press to show that it's from one of the three agencies that's covered by the Act. A number of reporters get subpoenaed to testify. They all say that they promise confidentiality to their sources and won't testify. The courts hold that they have to testify. They refuse, and they cite the First Amendment as their protection, and the courts hold them in contempt. And now the issue is before the Supreme Court whether to take the case or not, about whether or not they were properly held in contempt or whether or not they indeed had a First Amendment right to keep their sources confidential.
Put yourself in the position of a government civil servant who has to process freedom of information cases or privacy cases. You can get this nerve-wracking in terms of the country.
No, I think one of the dampers are various proposals to deliver administrative or criminal sanctions against people who release classified information. Now, whether by leak or whether by application of specific guidelines for declassifying information in which you apply it in one interpretation, but you are accused of misinterpreting that, and therefore you've illegally leaked information, you could be subject to criminal penalties. That's a real damper for people, and it makes you look very closely at what you're going to release and not release as as a government bureaucrat.
Would a federal shield law make a difference? Do state shield laws make a difference?
Yes, they make an enormous difference. And just to kind of draw out the distinction, 30 some odd states now have shield laws that apply in proceedings in state court to protect journalists. They differ, and they have differing terms, and their protections in some states are broader than in others, but there are 31 states, I think, that have shield laws. 49 states, either by shield law or by judicial decision, recognize some form of reporter's privilege. With these recent judicial decisions in the federal courts going against the press, there's a real question about how much protection the press has in the federal courts. So there has been an effort in Congress to introduce a shield law, a federal shield law, that would mirror the provisions of some of the better state shield laws. There have been a couple of hearings in the Senate Judiciary Committee. I testified at one last summer. There's some hope, but the legislative process is what the legislative process is. There is still some hope that a federal shield law will be passed at some point. It would make an enormous difference. So just to give you one example, Judy Miller spent 80-something days in jail for declining to reveal the identity of a source in the federal district court not too far from here, a few blocks down. If she had received the same subpoena across the street in the Superior Court of the District of Columbia, she would have had an absolute privilege under the D.C. shield law not to reveal her source and wouldn't have spent the day in jail. So it's an enormous difference.
Yeah. Well, let's go to the students and see what questions you all have. Who would like to come up with a question?
you guys are looking for questions, can I ask one question of
Sure.
our colleagues here? Going back to the whole question of which period you were most interested in and so forth. What case would you have most liked to litigate in your field? And Sharon, what president would you have been most interested in? What White House have you been most interested in being part of?
You go
Oh, very interesting question. I think of the presidents for the records that we have,
For the records that we have.
I think Harry Truman. I've been very interested in being a part of that White House and seeing his decision process on some very important issues, the decision to drop the bomb, the decision to integrate the armed forces. I think those are very, he lived in very interesting times. He was a very forthright person. He wasn't a person, I don't think Roosevelt anticipated that he would not be president. And Truman was a surprising choice and turned out to be a surprisingly effective president.
Who left office with a 32% public popularity rate.
Popularity rating. Mm-hmm.
Lee?
That is a very, very good question and a very hard one. I suppose that it would have been New York Times versus Sullivan, which is the libel case against the New York Times for publishing an advertisement that allegedly defamed the police chief of Montgomery, Alabama. And what's significant about the case, of course, is that it totally revolutionized the way the courts look at the First Amendment, and kind of goes back to where you started this discussion. What's the role of the free flow of information in a democracy? And that's the case in which the court really said that's the basis of the First Amendment. We have to interpret the First Amendment based on the kind of guiding principle that what we should be doing is trying to maximize the flow of information about government, about the people's business to the people. And that case was such a good vehicle to litigate that issue. There's a famous old story that the Commissioner Sullivan, who was the police chief in Montgomery, who was the plaintiff, said to his lawyer when he won in the Alabama Supreme Court and the Supreme Court of the United States agreed to hear the case, he said to his lawyer, what are our chances in the Supreme Court? And his lawyer confidently said to him, well, let's put it this way. For us to lose, the Supreme Court would have to overturn 200 years of established precedent. And that's, of course, what happened. So if I could have done that, I would have really enjoyed it.
When the case was argued, was it clear how big the stakes were, that this case was going to be an important vehicle?
Oh, absolutely. I mean, you have to recognize that at the time, I think there was something like a $500,000 judgment against the Times in the Sullivan case itself, which in those days was big money. But not only that, there were a bunch of other cases in the queue where other people similarly situated had sued the Times, and it was all about reporting on the civil rights movement. It was a coordinated effort to scare newspapers like the New York Times out of Alabama and out of the South so that they wouldn't be reporting on what was going on down there. And I mean, there's language in the opinion that suggests that the stakes in terms of the ability of the press to report on the most important contemporary domestic political issue of our time was really, at stake there. What it was unclear was at stake at the time was the whole way we look at the First Amendment and the whole basis on which our First Amendment jurisprudence as a going forward matter would be defined. And the great thing about the case, some would argue not the great thing about the case, but the great thing about the case was instead of focusing on the facts of the particular case and just undoing that injustice and kind of sending a signal to the Alabama courts that you can't do this, the court went broader and established this whole framework of looking at the First Amendment that has really revolutionized the way First Amendment rights are adjudicated in our courts.
Mm-hmm.
Okay, Alan, you have to answer the question.
That's right.
Whoops. I was afraid you were going to say that. I think I would have liked to have been Harry Hopkins in the Roosevelt administration with the room right next to the president's in the White House from 1933 to 1945 until Hopkins died, and had a chance to basically witness and observe, at the same time influence flow of history, what to me at least is probably the most dramatic set of turning points in American life, from no government or very little government intervention to massive government intervention against the Depression, very little of which worked, to the rearmament of the United States, to the fight against Hitler, and the Japanese militarists going through the entire war, and coming out at a time when you were defining the nature of the post-war world. That's the administration I would have loved to serve.
Mm-hmm. Yeah, and at that time period too, you get so close to the president for
Exactly.
all of the day, just going in and out. And of course, he lived at the White House. I think I would have liked to have been. I'd like to drop in on the Washington administration and see the degree to which the precedents that were set, that the president really thought about those precedents, what he was doing, and what his ideas were behind
You're
it.
talking about George Washington now.
Yeah.
You'd have to travel from New York to Philadelphia to
Right.
and all the rest of it. They didn't meet very often.
No, but just on a regular basis, but what he was doing, how he was making decisions,
Sure.
what were the ideas behind them. But of course, as a woman, I would have been nowhere near.
I think I also would like to have been the Eisenhower speechwriter who did Eisenhower's speech on the military-industrial complex. What was the thinking, what was the dialogue between the president and the speechwriters on the writing of that speech?
Yeah. Do we know for sure who wrote it?
No, I don't.
So I think it's been somewhat murky as to exactly who wrote it and which portions. Now I know you've been going to the Reagan Library. I was looking at a speech that he gave to the Houses of Parliament, and you see
1982.
all of the drafts. And you see the marginal notes that he wrote, and you see the difference that he made in that speech, that the president himself made, because he lifted it up, I thought.
And it took a year and almost a year and a half to get something started after that, because I was part of that process. But the Dems and the reps and the congressional people and the party chairman, and the labor people and the business people sat and debated what they should do for over a solid year before they finally agreed to work together. And out of that came the National Endowment for Democracy. I was the project director of that.
Yeah.
And out of that came the center that I ran for 18 years, the Center for Democracy. So that was a part of history that I rather enjoyed living through. But the speech was terrific. And it's really the predecessor of the speech that President Bush gave, or some of the speeches on the democratization issues. At the time was the Cold War. But Reagan was predominantly interested in long-term approaches to democratization in Central and Eastern Europe and the Soviet bloc. Included the rest of the world, but it sort of took second place. But it kicked things off.
Yeah, and it was interesting, just, you can look at the records and see how much of that speech was him.
In my office, Martha, I have two portraits. So we have the Presidential Library portraits running throughout the archives, but the two portraits in my office are carefully chosen, one of Franklin Roosevelt, one of Ronald Reagan, because they remain the iconic figures, the iconographic figures for those of their party. There isn't a Republican who walks in the office that doesn't smile when he sees Reagan's portrait, and there isn't a Democrat who doesn't smile when he sees FDR's portrait. So it works.
Yeah. Do we have some questions from Towson?
Got a hand up there.
How effective do you think FOIA is at disseminating information to the public, considering the discretion of the administration on what they're going to release, and the fact that Congress is not even accountable to this?
You want to start?
I think the bottom line on FOIA is that if the government wants to withhold something, they can withhold it for an awfully long time. So if you're looking at FOIA as some sort of panacea that will unlock the secrets of government, you're going to be sorely disappointed. On the other hand, if you want to learn a lot of important and interesting things about your government, FOIA is a very useful tool to do that, and we're better off having it than not having it.
Do you think also that its presence makes a difference as far as officials are concerned about what they do, that they know that exist?
I'd be interested in your perspectives on that. From my perspective, it's interesting. I mean, FOIA has been with us in its current form for so long now that there is a kind of freedom of information bureaucracy that has grown up that believes in principles of freedom of information and actually considers it their job to facilitate the dissemination of information, and that's a positive thing. As a practical matter, at least in the stuff that the news media tends to be interested in, we have this kind of tennis ball that gets hit back and forth across the net. Reagan and Bush 1 are president, and the Attorney General issues these guidelines that say, oh, we're going to, be very chary about what we give out under FOIA, and if there's any exemption that possibly applies, we're going to invoke it. And then Clinton bats it back across, and he goes, oh, no, we're going to be very liberal about FOIA, and if there's any way we can disclose the information, we will. And then Bush 2 gets in, and he changes it back the other way again. And now supposedly Gonzalez is looking at it again to decide whether he's going to change what Ashcroft had to say. But the administration does, to a significant extent, set the tone, but that's counterbalanced, like everything else is in Washington government, by the fact that there is a permanent, semi-permanent bureaucracy that has its own allegiances with respect to the principle.
I don't disagree. Sharon.
Well, I want to make sure we don't leave an impression with the students that to get information from the National Archives, you need to file a FOIA. Because for the most part, the records are open and available, and you only need to file FOIAs for those records that have yet to be processed. And for the most part, those are presidential records and records that are classified that haven't been reviewed yet. But I would say if you're planning on graduate study, don't use FOIA as the principal tool for getting information for your dissertation.
You've got 9 billion pieces of paper.
Because you'll be working for a long time. You can, though, go to the National Archives or one of the presidential libraries when you're thinking about a topic for a dissertation and say, okay, what's out there, what's open, what's in the realm of material that I could begin my research in, and start from there.
You will never meet a more responsive group of archivists and librarians than you will at the National Archives. They will help you in whatever interests you have. They will help you define them. So I strongly urge you to come and take a look at what we have. In terms of the impact of FOIA, I share most of what you were saying, Mr. Levine. That it's an informational tool. It's not an informational panacea. And nobody could have predicted at the time that FOIA became expansive with the amendments in the 1970s, that perhaps the major user of FOIA, not even the media, the major user of FOIA are business people, are companies, searching for trade secrets, searching for leverage, searching for advantage, searching to discombobulate their competitors, and God knows what else.
Why they didn't get a contract.
That's right. Why somebody else got the award. It was a stunner to me when I was doing a little bit of a study of FOIA and the Privacy Act in the late 70s, early 80s, and I just came across this stuff, and I just couldn't believe it. Eventually, I decided there was no need for my study. We knew what was happening there.
I also think it's interesting that many of the state FOIA laws are far more responsive to the FOIA requester. I know in Texas, if you file a FOIA request and you don't get an answer within 10 days, the government loses its right to restrict the information.
Right.
And what kind of information has come out as a result of that?
Well, I know it's very interesting for when President Bush, the current President Bush, left office, he was the governor, he had been the governor of Texas. And the governor's records are the property of the state of Texas, but the state legislature passed a law that enabled him to have the records deposited at his father's library for future transfer to a presidential library that Bush would be at. Well, when we got the records, we soon discovered the state FOIA law. And our first responsibility as the proprietors and the operators of the presidential library was to be responsive to FOIA requests for the presidential records. So over time, we ended up actually, because we couldn't respond to their FOIA requests within 10 days, and that means if you're going to if you need to withhold any information, you need to write to the Attorney General and get the Attorney General's permission, and then you have some extra time to go through and review the material and decide what would be restricted. We said we can't meet those deadlines. So as a result, the records went back to the Texas State Library, and where they're being administered now. They may eventually end up in the Bush Presidential Library, but it will be at a time when probably there is little FOIA interest remaining in those records.
What are the information practices abroad? Compare our system, whether it's FOIA, the general relationship of the media to government. It kind of set us in terms of what happens elsewhere in the world. And what kind of trends are some of the trends that we have, trends that are worldwide?
The United Kingdom is the second leading source of information, if you will, the second freest country in the world, as far as I'm concerned, in terms of source of information, after the United States. And yet, you still have a D-notice, you still have the ability to prevent a publisher from publishing something, you still have very strict libel laws and slander laws, and defamation of character laws that make it very difficult. And if you lose, you pay. If you lose, you have to pay court costs. I'm sure Mr. Levine could go through a whole bunch of other restraints on that. That's the best they have. On the continent, it gets even worse, although there's some effort in recent years using the American and British models to sort of make some tentative first steps in that direction. I spent 18 years of my life working with countries moving from dictatorship to democracy. And one of the first things they try to get involved in were either freedom of information laws or laws that expanded the scope of information that was being released. But they ran into enormous roadblocks and problems. For example, in Eastern Europe, in the countries of the former Soviet bloc, the release of information was often a way of targeting your political opponents. Why? Because who was to say that what the secret police had put about them in the files was accurate? And yet the Germans released the Stasi files to a great extent. A number of the other countries released their files, and what they did was to cause political mayhem. And yet, but none of them really had the concept that we have of regularizing the release of information either through extensive bulk distribution of material that just comes out because it's declassified in huge bulks. I mean, we have hundreds of millions of pages declassified within 6 months to a year. Either that or freedom of information cases, which can be very helpful if they're landmark cases. You know. That simply doesn't apply in Central and Eastern Europe. And I can't think. Can you think of any other country that has anything like what we have in terms of the release of information? I can't.
What about also the kinds of documents kept, like say in Europe? Do they keep the same kinds of documents and make them available, like papers that deal with chief executive papers?
Václav Havel stopped by the office about 5 months ago. He's starting the first presidential library in Eastern Europe. In fact, he's starting the first presidential library anywhere outside of the United States, except as a Canadian Prime Minister. I think Diefenbaker has a library in one of the universities, but that's it. So our customs haven't really spread that far in this regard.
There are, the German chancellors have libraries, but they're really foundations and more museum-oriented than they are record-holding institutions. The records are in the archives, but the British Public Office, I mean, it's 50 years before they open the records up. Now, they're less restrictive at the end of 50 years, and you can get a lot of information, but you wait 50 years to get it.
Yeah.
I know there's been a lot of debate in various executive orders, whether it's on declassification or whether it's on the release of presidential materials. What is the time period that we should look at? If you look at a longer time period, there's less that needs to be restricted, or maybe you can have automatic opening. If you have a shorter time period, then you have a number of restrictions. Issues are still out there. The whole issue of declassifying records after 25 years. When the executive order came out in the Clinton administration in 1995, of course, there had never been an executive order on bulk declassification, so the government began working on declassifying its old files. Well, it was pretty easy when you were working on the World War II period or the pre-World War II period or the early 1950s to get a lot of material declassified. But as you got closer and closer to the 25-year mark, you got into areas of where conflict still continues. Sure. You get into the Middle East. You get into regimes that are still in power. Fidel Castro, until a few years ago, Saddam Hussein, but regimes that have been in power for a long time. And so the release of that information becomes problematic in the national security world. So what is the right time frame? It's a real debatable, I think, debatable topic about when you should automatically declassify material.
But I would make the argument, though, with all of that, that it's a bit like Churchill's comment about democracy, the worst form of government except for all the others. Our system, in some crazy, wild and woolly way, works. There's experienced lawyers like yourself who can go to the courts at any given moment that they feel something has to be litigated, but can also negotiate with the best of them to get what you need from something out. The media, it doesn't strike me as being utterly terrified these days of government. It's confronting government at every turn. It will continue doing that. And out of that tussle, we have evolved a system which doesn't fit, thank God it doesn't fit any other country in the world. The American system of media, like everything else about this country, is pretty much untransferable.
I would just say in answer to the kind of preface question to all of this, I don't think there's any question that in virtually all areas involving freedom of information and freedom of speech and freedom of the press, that the degree of freedom in this country is mega times greater than anywhere else. I will say, and why this is I don't understand, that the one area in which we are behind the rest of Western democracies is on the area of reporters' privilege. Even though the United Kingdom has an Official Secrets Act and the libel situation is quite more restrictive than it is here, for the reasons you were mentioning before, among others. There seems to be a general consensus throughout Western Europe and other Western-style democracies that a reporter's ability to keep a promise of confidentiality to a source is essential to the freedom of the press, something we have been unable to get our arms around in the same way here.
Do you think that we're just at the beginning of defining that? That it's something that's going to get defined through the courts?
I think it's I hope so. I mean, I think it's a historical accident and quirk, like a lot of the other things that make up our conception of freedom of speech and freedom of the press. But it's one that, because there has been no definitive declaration of what, at least from my perspective, common sense would suggest, that yes, you're going to have a less free press if a press can't go to people and get information about important matters of public concern under a promise of confidentiality and keep those promises. You're going to have less free flow of information, and that seems to be something that our courts have been slower to embrace at the highest levels than courts in other Western-style democracies. And, I said before, there was that whole 30-year period following Brandsburg, where Brandsburg was largely ignored, and the lower courts did readily come to that conclusion. But absent a Supreme Court decision saying you're right, and what we said in Brandsburg was an isolated, fact-specific kind of situation, we are, I think, behind in a material way where other Western democracies are.
It would be very interesting to see what impact the cartoon episode in Denmark has on media in this country, but particularly in Western Europe. Whereas I agree with you, in terms of laws protecting journalistic rights, I think they have been a bit ahead of us. But the fact is, this may not remain the same. In fact, it may be remain for very dramatic change there. Whereas we have a tradition in this regard. It's the late Daniel Patrick Moynihan was a terrific senator from my perspective. Once said that we have the most self-corrective country the world has ever known, or ever will know, and it's true. It's true. The famous line of Carl Schurz, "My country, right or wrong," that wasn't the line. What he said was, "My country, right or wrong, when she is right, support her. When she is wrong, correct her." It's the legitimation of dissent and of media dissent.
I should say one other thing on the issue of the Federal Shield Law. The primary Senate sponsor of the Federal Shield Law is Senator Lugar, and he's the sponsor because he's chairman of the Foreign Relations Committee, and he has said publicly and testified in support of the Shield Law that he has a hard time going around to other countries and telling them how they need to democratize and how they need to have more open societies when we are not practicing that at home, at least in that one area.
But an unexpected thing, more or less, he's an old friend of mine, a more or less conservative Republican senator, being the chief sponsor of this. Lugar is not a Democrat, he's not a wild, not a liberal.
That's true. And the chief sponsor in the House is Mike Pence, who's a very conservative
Right.
Republican.
Okay, so these issues go beyond
Yeah,
partisanship.
they're not partisan.
Towson, you have a question?
Anyone can answer this, but do you feel that the Freedom of Information Act and any act that basically amps up the First Amendment is a contradiction to national security?
Well, the Freedom of Information Act itself has an exemption for national security information. So anything that's classified is by definition exempt from disclosure under the Freedom of Information Act. And a lot of the litigation that goes on is over whether or not the national security exemption has been properly invoked. And as a practical matter, the courts defer to the executive branch on issues like that, on the theory that the courts are not competent to second-guess the president and the administration on issues relating to national security. So as a practical matter, a statutory scheme like the Freedom of Information Act really doesn't, at least as far as I know, has not had an adverse impact on national security.
I agree with that.
I have a question about the use of documents, not by just private citizens, but the use of documents and information by government itself. What difference does it make to have records as far as things that, say, presidents have learned from documents about their predecessors? Can you think of instances where presidents have asked for documents and have acted on the basis of they've been able to learn things by looking at what happened at an earlier time period? And also with the press, the way in which government officials have acted on the basis of something that they have seen in the press, that they've learned through the press. So,
Well, let me take the most unseemly episodes. Beginning with Franklin Roosevelt, he put J. Edgar Hoover to great use. And there's a good deal of material in the files in which FDR has at least sanctioned or accepted the monitoring, the wiretapping of his political adversaries, of the Charles Lindberghs, of the newspaper editors such as Frank Waldrop and Cissy Patterson in Washington and others. You can read their tapes. Roosevelt rather enjoyed listening to that material. J. Edgar Hoover, of course, presented President Kennedy and Bobby Kennedy with evidence enough to keep them in office of their relationships with women. That was, but then they also then went ahead and it was Robert Kennedy who signed off on the wiretapping of Martin Luther King. Was that a reasonable thing to do? No, not at all. There was so little. There was a tiny bit of evidence that there were some radical associates around King, but not the bulk of the people around him were certainly not fit subjects of criminal investigations.
why did Roosevelt ask for those taps? Like, say, of Cissy Patterson.
Well, curiosity and political advantage. Why do people do these things? I have no tunnel into his mind. I don't know. There have been a lot of speculations by historians, but it certainly is a great political advantage if you know what your adversary is thinking. What was Watergate all about?
Yeah, yeah,
But what did it start out as, at least, anyway?
yeah.
Sure.
Actually, in answer to your question, Martha, I'm actually rather surprised that I can't think of many instances where the present administration seeks counsel through the records of the previous or any previous administration. It seems more something that happens in hindsight rather than foresight. For example, the 9/11 Commission that was established to look at what was known about terrorist threats in this country. And all of that was long after 9/11, not in preparation for what Bush's terrorism policy should be, what were the terrorism policies in the Clinton administration or the former Bush administration or even Reagan before him. These things seem to come as reviews in hindsight. It's interesting, when a president leaves office, he takes with him or turns over to the National Archives, the records, we go in by January 20th at 12 noon, the National Archives has emptied out the White House. Literally emptied it out. The file drawers are empty, the computer drives are empty. There is not a piece of paper left in the White House, except for a few national security directives that are left back, as historic files at the White House. Otherwise, it's not there. So each president comes in and starts fresh, creating records and developing their policies with little, I think, review of past practices. I'm surprised at how little there is, or how little inquiry there is about what happened.
It's unclear whether we take the candy bars and the pizza boxes as well.
So do you not get requests from the current occupant of the White House for records?
Occasionally, but it's very infrequent. And as I said, it's more in response to something that's been in the newspaper or an event that occurred, and they're going back and studying what led up to the event, than in term. But President making a new decision.
The questions, one of the questions, Martha, that you've been asking require, in some ways, more detachment than I think any of us at this stage in the game have, at least about the present. Take, for example, the issue of the controversies over the war in Iraq and administration policy generally. The country obviously is divided significantly in these issues, but when you look at what's actually happening vis-a-vis the war, and there are any number of cases that are being litigated, and there are issues related to Abu Ghraib, issues related to Guantanamo, and other things. Then you go back to the First World War, and you had thousands, literally thousands of Americans, just or if they were foreigners that were living in this country, just hoarded onto ships, sent out in the aftermath of the First World War, the Red Scare. And imprisoned during the war, Eugene V. Debs, a socialist candidate for the presidency, imprisoned by Woodrow Wilson, a bona fide liberal president, and released by Warren Harding, a bona fide conservative Republican. Second World War, you have the incarceration of the Japanese Americans, one of the great tragedies of American life. Vietnam War, you had conflict after conflict in terms of protests involving millions of Americans, hundreds of thousands of clipped. Very extraordinary measure of intensity. How will historians 50 years, 25 years from now think about this war in terms of the impact on the country? I'm not. I don't know. I just don't know.
Yeah. Right.
I don't think I'm going to be around to find out. We'll see.
Yeah. Well, I don't know, all the stem cells.
That's another show.
Lee, when you look at the stories that have come out of news organizations, just in the last year, probably some that you're dealing with, you can see that government has acted on the basis of some of the information that has come out of reporting. Well, like for example, the NSA eavesdropping, all the actions that the members of Congress are taking is really based on the New York Times stories, and then subsequent stories that detail more of it. Can you think of other kinds of stories that have been important, of what they've come out from reporting?
Oh, sure.
But government then becomes consumed with it.
Oh, absolutely. And I think that, interestingly, in this day, in this era, and I'm talking about the last few years, when all three branches of the federal government have been controlled by the same party, so there isn't the same kind of checks and balances within the system that there's in other eras been. The press really has been the only check, and the press is got the most power in terms of getting the information out there in a way that the minority party and the Congress can react to, or opposition groups throughout the country can react to, and then further publicized. But it's not just the NSA; it's Abu Ghraib, it's the secret prisons, abroad. And regardless of what you think about these things, getting those issues on the public agenda, the rollout of the prescription drug benefit and the perceived problems, the Hurricane Katrina fallout. I mean, all of that comes to public attention because the press digs it out and reports on it.
Well, I think we're going past our time.